Child Protection in Iowa. Brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15 in Greater Des Moines, Iowa. You can watch our program on Sunday afternoon at 1 o'clock, and again we repeat it on Wednesday evening at 9:30. You can also watch this program in Council Bluffs on Cox Channel 23. It airs out there every other Thursday at 4:30 p.m. You can email us at vocaliowa@mchsi.com. My telephone number is area code 515-276-3956. John's number is 515-282-2672. We appreciate hearing from parents that are having trouble with the Department of Human Services where they're losing their children. That's what Vocal is all about. We're not attorneys, but we're here with a lot of experience to help on a one-to-one basis. My name is Don Bergmeyer, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report that stands for Child Protection in Iowa. And we can't call him a guest anymore because he's a regular on our show. Terrance Walker will be getting back to him in just a moment to introduce an online guest from the San Fernando Valley. So we'll probably have to go long distance on that one, won't we, Terrance? Well, CPI stands for Child Protection in Iowa. It's our intention to influence public policy with respect to child protection issues. So that's the theme of the program. For right now, we're going to switch immediately to Terrance Walker. Terrance Walker is the self-appointed judge of the judges, and he knows a whole lot about the judicial system. And if we don't get the judicial system straightened out, then we will remain with some difficulties in any other field of endeavor that's attached to that. But for right now, let's talk to Terrance Walker.
Well, thanks for having me on again, John. I guess, like you said, I am the judge of the judges. Nobody else can do it better, so I'm doing it for everyone. I think that this show should air on the same day that the Super Bowl's aired, and in that light I would like to make a comparison to the judiciary and the way they relate to what in the game of football is called a referee. Now, the referee in the same light of a judge is supposed to be fair and administer fair calls. Now, if we have a system of justice where those referees are not fair, then we won't have a fair game. So I think that in that light, we should try to make our judges be fair play callers so that we can have a fair game, because they are more important than a referee, because they affect all decisions of conflict as it relates to life, liberty, and property. And I've got a gentleman on line A, and he's instrumental in the legal reform movement. And not only is he instrumental, but he has energized the legal reform movement as it pertains to the judiciary and trying to get some accountability and bring some sort of fairness back to the whole judiciary system. And on the line I have Mr. Branson. How you doing, Mr. Branson?
I'm doing fine. glad to be on the show.
I'm glad to have you on the show. You've created a fair amount of controversy here with the proposals that you've made there. Can you tell us a little bit about that?
Well, since you're touching on the issue of controversy, I just been informed that the legislature of the state of South Dakota, which is our first state to get this on the ballot, has voted approximately 90-some legislators out of the possible 105, which have signed a resolution opposing our initiative that's on the ballot in their state. I think this is the first that's ever happened in any initiative in our country. So yes, you're right. We are very, very controversial.
And
actually, what we're doing is we believe that the people should be in charge, and we are a nation that's a nation of laws and not of men, and that the people should be in charge of their government, and not vice versa. To accomplish this purpose, what we've done is use the initiative process, which I understand you don't have in Iowa there, but we do in just about 50% of the states, where the people can go directly to the people, acquire their signatures, get this on the ballot for a constitutional amendment, and then when the next election comes around, the people get to vote on those things if they agree that we need judicial accountability.
Exactly.
We are actually stirring up controversy around the whole nation, even though we're spotlighting our efforts on the state of South Dakota. We're having newspapers from all kinds of states, for example, Texas, of course, California, a couple of newspapers here, one in Oregon, we have one in Canada, one in Idaho, and Iowa, and Kansas, Missouri, New York, to name some of them I'm knowledgeable of. So we're getting tremendous coverage.
And
a lot of them, of course, are not favorable, but that's okay. We are getting the message out. We believe there's no such thing as bad advertisement.
Right. And Ron, can we back up for a minute? I just wanted to let the people know, for those that aren't aware, what is the initiative all about that you're supporting? I know you're with an organization called Jail for Judges. Can you explain what the initiative entails as it relates to the judiciary?
Sure. First off, JAIL is an acronym. It stands for Judicial Accountability Initiative Law, and non-initiatives, that's the Judicial Accountability and Integrity Legislation. What we have done, and I'm actually the author of it, is I wrote up an initiative that establishes that the creation of a statewide grand jury, special grand jury system, to which the people can go after they have exhausted all remedies within the existing judicial system. Essentially, it allows and requires that the system work the way it's supposed to work. A person goes to court, argues their case, urges the law, and lets the judge rule on it. If the judge insists on going some other way than the law, and you brought to his attention, you've established it's a willful act on his part. And usually what happens is when judges have made their decision, and you come back for a reconsideration, they usually just say, well, I've already made my decision, and that's the way it's going to be. Well, jail accepts that, and of course your remedy is to go on appeal. Now, here in California, we have an appellate court, and then we have a next major step up above that is the state Supreme Court.
Right.
It appears that some states don't have a appellate court and a Supreme Court, but you must exhaust, or at least attempt to have exhausted, all of the remedies that are afforded you on the books. Having done that, or attempted to have done that, then it opens the door within the 6 months Now, the person who's charging the judge with this bears the burden of showing that they argued the law and show where the law is, and that the judge, when it was brought to his attention, did it willfully. The special grand jury gives the judge his opportunity to oppose. He is called upon to submit his opposition, and he can argue whatever he wants, which basically are limited to two issues. Either A, I did not violate the law, or B, if I did, it was merely a mistake. That's his only two defenses. And then the special grand jury, by a majority, decides whether the judge did violate the law and whether he did it willfully. If they determine that, they have the opportunity to strip the judge of his judicial immunity, which is a doctrine that judges have created for their own self-protection. It strips him of that, and they have to go to trial on the merits if the person bringing the complaint chooses to sue the judge. We also have a 3 strikes and you're out, which essentially says that if a judge on 3 different separate occasions has been found to violate the law and do it willfully, it removes him from his office as a judge, and he can no longer serve as a judge within that state. Further, it deprives the judge of 50% of whatever his retirement benefit would have been had he retired normally. It throws him out of office and takes 50% of his benefits from him.
Wow.
We also have a criminal side to this. The criminal side essentially says that within 90 days of the commission of any crime, you can go to the appropriate prosecutor, which would normally be the district attorney, and you file an affidavit of criminal conduct, which would support probable cause of the alleged crime. The district attorney, as in the case here in California, would have 120 days to begin prosecution of that judge, or the person having filed the affidavit can forward it directly up to the special grand jury, and they will examine it for probable cause of criminal conduct. If they find that there's probable cause, they may indict the judge and assign their own special prosecutor that works with them, and the special prosecutor will go to trial in front of a jury. It's instructed they have the power to judge on both the law and the fact. They will determine the innocence or guilt of the judge, and if they find the judge guilty, it is them, not another judge, who issues the sentencing.
Okay.
They can sentence the judge to whatever they choose to do by their the common, the average of the jurors, but it still has to be within the lawful parameters of sentencing guidelines. So it is true that a judge could go to prison or jail as a result, but that's a small part of it.
Okay. Well, that seems to be a more elaborate explanation or process than what the media has been portraying in the paper. I've seen several articles.
The media has come up with every kind of a convoluted idea, such as saying that the purpose of jail is to release prisoners out of prison so they can go and serve on the grand jury and settle their judgment over the judge who sentenced them into prison. The provisions of jail on that part says that no person that is imprisoned or on parole for felonious violations against persons may be a part of the grand jury. They're excluded, specifically excluded.
Okay.
They just come out with just the opposite. Also, they argue that we will interfere with the independence of the judiciary. But what it really amounts to is the judges want to interfere with the independence of the people that sit on the grand jury, because they have the power to decide in their own judgment whether the law has been violated and whether it's been willful or not. They just want to keep away from the people. That's what this whole thing's about.
So it's about power, basically.
I'm sorry?
I said, so it's about power instead of independence. I know they like to say that they would
Exactly.
like
Well, what
independence.
it amounts to, what they say is, we are trying to let politics interfere with their judgment on the law. When actually what's happening is just the opposite. They want politics to intercede rather than the law because they don't want to be held to the law.
Exactly.
So what they're doing is anti-judicial independence.
And you have...
In fact, really, when you talk about the three branches of government, each being independent of the other, each is to be a check and balance on the other one, i.e., the legislature can impeach judges, and the judges can hold legislators in contempt. And of course, you got the executive, and any one of those they can prosecute a judge if they find that there's a criminal conduct. But usually the prosecutor doesn't prosecute judges, the legislature does not impeach judges, and judges don't do anything to either one of the other two branches. They're all in it together.
Exactly.
It's like a massive conspiracy in which the victims happen to be the people.
Now, what do you say to people that say, well, the independence of the judiciary is something that should be in the place? They should have independence.
Well, there's nothing wrong with independence, but the thing is, like I say, they're not independent of the people, they're not independent of the law. They are independent of the other two branches of the government. That's the point. See, they miss what in the world independence is. I do believe in judicial independence. It's just what they're interpreting it as. And
Right.
When that grand jury looks into and seeks for an indictment or to remove judges of their accountability, remove them from actually immunity from accountability, then that's we're holding the judges accountable, and you cannot say that they're independent of either law or the people. In fact, we the people institute our government, and government operates by the consent of the governed. We establish a constitution, and the Constitution establishes government. We're actually 2 rounds up above the judges.
Yeah, I agree. Now, you had an interesting quote on your website at jail4judges.org. That's jail4judges.org. The quote was from Thomas Jefferson, and he said in a letter to Spencer Roane, this is 1819, said, "The Constitution on this hypothesis is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please. It should be remembered as an axiom of eternal truth in politics that whatever power in government is independent is absolute also, in theory only at first, while the spirit of the people is up, but in practice as fast as that relaxes. Independence can be trusted nowhere but with the people en masse. They are inherently independent of all but moral law." I thought that was a really interesting quote. I just wanted to give you kudos on that quote because we have been inundated with numerous articles. And matter of fact, the Iowa Supreme Court State of the Judiciary address by Chief Justice Lavarado here in Iowa addressed the whole matter of accountability and said that the independence is supposed to be paramount, and that they are accountable. And I thought that the examples that he laid forth to show that they were accountable actually did the opposite. But this is what we see a lot, not only from what they say, but from what they put in the legal opinions. And I just wanted to also ask you, what was the motivation for you, or drive for you, to push for this legislation? I know there's got to be a story behind it.
My experience, I started out going up against the government. When my rights were violated under law, I wound up going into court and urging the law was violated. What would happen was the judges would always cover for the government. You could count on it. Eventually, I found that the judges were so bizarre in their rulings and defending to the government that I began to sue the judges.
Yeah.
And then the judges started urging, judges judging judges. They would always cover for one another, called judicial immunity. So I started attacking that issue of judicial immunity. But of course, it was always heard by other judges who were covered by judicial immunity.
Yep.
And so there was this huge conflict of interest. And no matter how refined and how accurate you are, you're not going to get anywhere in a system that covers its own behind what the doctrine has created. It's not legislation. It was not passed by any legislature, either state or federal. But yet they essentially legislate themselves from the bench that they were covered by judicial immunity and not accountable to the law. Now here's the paradox they have in South Dakota. We are pointing out, of course, that judicial immunity should be conditioned. The defense, which are the judges, the attorneys, and usually the Bar Association, they're arguing that the judges should be covered by judicial immunity.
Okay.
Yeah, and so what it winds up being is they're arguing our argument in a subtle way. In reverse, we're saying they should be accountable, and they're saying, yeah, they should be. We're saying they should. Judicial immunity should not apply, and they're saying that judicial immunity should apply. So essentially what they're arguing, if people listen, is saying what the judges are arguing is they're above the law. Exactly. Of course, they don't want that as a defense. They love it. But as a political issue, they don't. They try to recant and say, well, we are accountable. And I hear them talking out of two sides or a lot, mouths saying that the judges are accountable. They're accountable to commissions. They're accountable by recall. Or accountable by votes and by appellate court. The thing is none of those things really work. And so they're arguing that judges should be unaccountable, and we shouldn't interfere with them because when we do, we're interfering with their independence of the judiciary.
Yeah.
So they're in fact arguing our argument. And eventually, if I get my way, which I'm suggesting, is that we put billboards up throughout the state of South Dakota that says, vote yes on Amendment E because judges are not above the law. Now, what we're hoping to do with that is we'd like them to controvert that. I.e., yes, they are above the law. They don't want to argue that.
Well, I don't think they'll do that. They'll resort to the tactics like I see in the paper, where I've seen a couple times where they put, and they must have some of these journalists on the payroll, because sometimes they'll say it seems that the initiative that you set forth is to basically to serve as a means for people to get a judge removed for a ruling they feel was disfavorable.
Yeah, you don't like, What is interesting about that argument is they issued a poll that said just like that, hopefully that it would stick and be negative to the voters.
Yeah.
They asked the ridiculous question, do you think that the people should be able to go to the special grand jury and sue a judge for decisions they don't like?
Exactly.
That poll came back essentially 49% to 51. That means the jail that they are presenting to the people of South Dakota is only one point difference to winning the issue.
Yeah.
Of course, if you turn the question around proper like we're doing, it says, do you believe that a judge should be accountable to the law he's sworn to uphold and defend? You got a totally different question there.
I think you'd have 99%.
For people to answer that question, of course, who in the world in the right mind would say, no, I don't think they should be accountable to what they've sworn to uphold and defend.
Well, I think you'll have about 99%. That 1% being lawyers and judges.
Right. This is what we're up against. Of course, we realize that our opponents have control of the media, but what they're doing is by asking their dumb questions and pushing out their garbage, There's enough people out there that think for themselves that say, what is this? See, let's put it this way. There's nothing that's 100% bad.
Exactly.
I mean, either this thing's got to be awful good or awful bad, but, you know, how could everybody be gathered together against an issue that's so bad that no one's ever heard of something so bad before?
Right.
People tend to start thinking that maybe we're being duped. And that's, of course, what we're counting on a great deal. We're going to have a little bit of opportunities ourselves to take a shot at the people because we're putting out flyers and material. And, of course, like when we go on the radio, sometimes in the newspapers we do get to rebut. So we do get a shot back.
Okay.
So we're not that far off from winning if we haven't already won the issue. In fact, I think we already have.
Well, I've seen recently some good press on the jail initiative from the Bar Association, surprisingly. They did.
The American Bar Association, and when I say that, I'm talking about contrary to the State Bar
Right.
of South Dakota. The American Bar Association is acknowledging that there is some big problems with the judiciary in this country, at least a perception that it's not fair and ethical. So I'm kind of amazed myself at some of the good publicity we've gotten from those who I would tend to think would have the most interest in condemning us. Once in a while, we're getting some fairly well and, should I say, good reporting because they report on both sides. And that's, of course, what we ask. You know, we're not saying the other side should not be able to rebut us. We just want the opportunity to state our position. Yes, you're right. We are getting good publicity from some of our sources that surprised me, really surprised me.
So what's the end result of this? What do they have? Some sort of vote in the House in South Dakota to not support the or some resolution against the amendment. What's the end result of that?
In fact, just before we made contact here, on the program here, I was called by the media in Rapid City Journal in South Dakota.
Okay.
And they asked me if I had gotten notice from the legislature that they had passed a resolution against us. I said, no, I haven't. Well, some kind of a notice that is, right? Well, first off, I'm sure the state, and we're going to be looking into this. Now, this just happened. I mean, this happened like, probably no more than 2 hours ago. That's what we're talking how immediate. So we're going to be examining this from several different angles. First off, the legislature are representatives. They get paid. They pay tax dollars. Now, anybody knows that a legislature cannot use the auspices of his office to campaign for his reelection. It's a conflict of interest. They can't use taxpayers' dollars to use their office, their copy machines, their telephones, or any staff people in the promotion of their reelection. And that's pretty well universal across this country. And we understand why. Well, if it's wrong to campaign for your reelection on tax dollars, is it not also wrong for all of them to get together and campaign against a people's initiative that's on the ballot? I mean, what they're doing is they're using tax dollars to campaign against something that the people are voting on. And that's unethical.
And I don't know.
Here's what I see that's brewing here, and they just made it official by signing this thing. We have a major ethical scandal going on in South Dakota. They haven't yet felt the repercussions of it, but I am of the opinion that this thing is going to do a kickback on them. Because once the people start realizing that their money is being spent against their interests, that may be the issue to say, well, gee, if for no other reasons, you should get rid of this legislator because he's abusing your funds. He's taking your funds and against your interest. And I say this, even if 50%, let's call it a 50-50 here. If there was a 50-50 vote on this subject, you got 50% of the people in South Dakota that are not represented at all. And didn't our country start off with the complaint of taxation without representation? Where's the representative? Well, they haven't got one. All those that were for this measure don't have a representative.
Yeah.
Not only do they not exist as a representative, but they are contrary to their representation.
Yeah.
The fact that they've done is essentially become an opponent to those whom they represent. Now that's an abuse of their money and their office, yeah, because they're put into public trust.
Exactly.
I mean, if you're going to hire an attorney to defend you, what if you discover that he's working for the other side? What would you say?
Yeah.
What would anybody say?
I would say vote him out of office. That's what I would say.
This is the same thing as hiring an attorney, and that attorney is working for the other side against you.
And they're supposed to be the representatives.
This is statewide now. This has heavy implications. Now, what it's going to do, because this is unprecedented, is this is going to catch the news clear across this nation. Here's what I anticipate as we sit here talking. There are news people across this country that already picked up their vote to pass this resolution.
Right.
And they're making news stories right now. And probably by tomorrow, you will see these things out there on the streets in the various locations across this country. Legislature of South Dakota passes a resolution against an initiative on the ballot in South Dakota. Well, I guess it depends on how one looks at it, but as the the way I see this is people would say, well, gee, isn't there something wrong with this?
I would definitely say so.
It's going to give us, see our battle line supposedly is with South Dakota.
Yeah.
And we expect to have opponents, and our opponents should be the other half of the people who are against us. And I'm emphasizing the word people, not representatives.
Exactly.
These representatives have the right to vote just like anybody else, and they can vote as individuals. But to go on record to campaign, which is unethical for them to do in their own behalf, I mean, this is, so what I trust we're going to see here is a big blow-up about ethics of the legislature of the state of South Dakota. And what does that ethics question revolve around? Jail for judges.
Exactly. Now, Ron,
I would like to just give a little commercial here so those that believe in what we're doing can get in contact with us or support us, okay?
Okay, we just got 1 minute here, too.
Our website is, please get your pen handy, it's Jail for Judges, that's numeric 4, like 1, 2, 3, 4, jailforjudges.org. That's our website.
Okay.
If you wish to write to us and get on our email list, we have jail news journals and we have a jailers list. I'll explain what those are. Our jail news journals is our newspaper to the world as we contact them. And you can get on that by writing us at Victory USA, quite appropriate, Victory USA at jailsforjudges.org. We'd like to hear from you. We'd like you to join up with us on our mailings. We get a lot of interesting material. I would say we have put out close to 10 million pieces of email in our existence. Now, it doesn't mean we've hit necessarily 10 million individual people because a lot of them are repetitious. But what happens, I figure that for every email I send out, on the average, there's about 10 more people that get our information. If you use that multiples of 10, if I'm correct about it, compounded by 10 million compounded by 10, you got 100 million people that this is getting out to. I've had people say, you would be really surprised at where your emails are going. They're going into the Pentagon. They're going into the legislatures around the states. They're going all over the place. I mean, and then who knows, after that, after the first level, how many are going out on the third? First levels to us, they go out to their second level, then who knows? They pick up on their mailing list. So
Okay, and
people
Ron,
that have 100 on their mailing list. Some may have maybe 4 or 5 or 6, but most everybody has some kind of mailing list, even if it's their own family members.
okay, and Ron, we've got to cut the program here short. We got about 15 more minutes that we got to dedicate to the other segment that we have. But I do appreciate you coming on our show, and I hope that you support our effort here in Iowa to get a similar piece of legislation passed. Unfortunately, we can't put signatures on the ballot or anything like that, but we did.
Understood.
We did.
Let me give you an email, not an email address, a mailing address. Those of you want to send a little money our way to help us out.
Okay.
It's P.O. Box 207,
Okay.
North Hollywood, California,
Okay.
91603.
Okay.
That's P.O. Box 207, North Hollywood, California, 91603. And make your checks out payable to jail.
Okay, and we'll repeat that at the end of the show. Did you also have that on your website? That address?
Yeah, so you'll find that information on our website, jailforjudges.org.
Okay, we'll repeat that again at the end of the show, Ron. I do appreciate you being on our show again, and we'll get in contact with you shortly after the show as well.
Okay.
Okay. So we'll look forward to.
On to another subject now.
Yeah, we're going to go on to the next subject here, unfortunately, but we'll have.
Thank you very much, and appreciate you having me on.
Okay, Ron, we'll be rooting for your efforts there to get the legislation passed there in South Dakota, and hopefully get those representatives removed as well.
Okay, God bless.
Thank you.
Thanks a lot, Ron. There you have it, one of the guys creating all the controversy here as far as judicial reform. There is also a petition online that we put online. I actually have put online here in the state of Iowa to get the jail law, we can't call it an initiative per se here, but to get the jail law passed here in Iowa. And you can go right to this website and not only view the law, the Iowa version, because each state is different. It's at weblocation1.com/petition, and you can go on in there and you can sign an online petition, but not only that, you can download a flyer at the other link at petition.doc. You can download a flyer, pass that out, have other people go to the site and sign their name online, and we're hoping to show this to the legislatures here. Hopefully they're a little bit more understanding than the legislature in South Dakota, and not so quick to side with the judiciary on this matter. But we're going to show these online petition lists to our representatives here in the state, and hopefully they'll pass some similar legislation here in the state of Iowa so that we can have some judicial accountability, because who wants to go to a game that's rigged? I mean, we're going to have Super Bowl Sunday here. Who would want to go to Super Bowl Sunday knowing that the referees do not play fair? Well, we can't have judges not play fair either. And, the jail initiative, even though the press likes to say that it's for people that have disfavorable opinions they disfavor a ruling, it's not at all for that. As we've heard from Branson, it's a very rigorous procedure to get a judge ousted, and they have to be in disregard of a law. And with that, I'll let the balance of the time pass it back to you guys. I'm sorry for taking so long here to get my point across, but with you, Don or John?
That was a good interview, and I appreciate you contacting this gentleman. Ron Branson is his name, right?
Yep.
As in Branson, Missouri? Ron Branson.
That's what I always think of when I say his name.
Okay. And basically what we have here is a problem that we dealt with a number of years ago. We're getting some Yeah, if you want to, you can pick up that other mic to replace that with Terrance. But we have a problem with something called divine right of kings in the middle centuries, and we overthrew the government that wanted to force that onto us. In other words, the king was accountable to no one except God. And for some reason, they've retained that same principle for judges in the United States, divine right of judges. That means they are accountable to no one but God. They don't say they're even accountable to God. They're accountable to themselves. And so I welcome this initiative that says, no, they're going to be accountable to the other branches of government. They're going to be accountable to the people. And I think it's reprehensible that someone would say that the reason why the people rise up against the judges is simply because they got a bad decision. Well, about half of the people that go into the courtroom come out with an unfavorable decision, right? So that's just unfortunately the way it happens. You got a mic there? Okay, good. So, Don, can you put up I need the one from C.S. Lewis that I handed to you a moment ago. Okay, in the state legislature, we have been talking about for quite some time a provision that they'll have to at least address in one way or another, and that is the 2,000-foot rule. Well, the 2,000-foot rule, unfortunately, is a bad law, and it is causing some real problems. And it should prompt our General Assembly people into reversing that rule. Well, let's see what one person says about it. We all want progress, but if you're on the wrong road, progress means doing an about turn and walking back to the right road. And in that case, the man who turns back soonest is the most progressive. That's by C.S. Lewis. C.S. Lewis is the author of one of the films that is playing here in the city. He's an author of great renown, and in this particular case, I think he has it right in his recommendation for the state legislature. And that is, if you've done something wrong, if you know it's wrong, then it's time to turn around, and the time to turn around is now. Get rid of this 2,000-foot rule. Let's see if we can't straighten things up. There are other things that we can do. And you know, one of the things that bothers me with respect to all of these intensification ideas is what happened to our people that we've gone to so much of this abuse of children. How is it that we still have children who are being sexually abused, even though the penalties have doubled since the 1st of July of 2005? Does the doubling of the penalties really help? Should we not pursue some other things? For instance, let's get the sex education out of the schools. Let's not awaken the interest of youngsters in pursuing these things. Let's not find junior high school girls or even upper elementary school girls who are willing to service high school boys in sexual practices simply because they've been told at school what safe sex is. And safe sex is anything that doesn't involve intercourse. Well, see, some of these goofy ideas that we've entered into causes young minds to go wild. And I would imagine that people like Bentley had their minds awakened to interest long before they should have gone that direction. I don't know just what the problem is with the Bentley boys, but there are ways of viewing things that differently than what we're doing now. You know, the principle falls into this analogy. Is it better to build a wall at the edge of the cliff to keep people from falling over, or would it be better to build a research center and a hospital in the valley below so you can patch them up after they fall? It would seem like to me if there are individuals who have a tendency to be wayward in their habits, in their interactions with children, it would be better to correct that at the right time, and also to remove those influences wherever they happen to be. And we're so careful not to tamper with such things as pornography. We certainly wouldn't want to put any prohibitions on pornography, would we? Because adults have the right to have access to it. But have you also noticed that in cases where there's been a child sexual abuse, that they also find pornographic materials? Is it really good that we should completely honor the First Amendment to the extent that we corrupt our society? I think some of these things should be looked into instead of building bigger and bigger prisons, having people serve longer and longer terms, and come up with some really silly, sick laws. Well, with respect to the 2,000-foot rule, I think we need to say so long to that rule. And I think that for the 6,000 people who have been seriously inconvenienced, I think the state legislature simply should draft some expenses for those people. Maybe if it was appropriate to give them $2,000 in the Katrina emergency, perhaps they should offer these people a settlement of $2,000, unless the individuals can show that they have encountered even greater expense than $2,000, being kicked out of their homes inappropriately. Now, the people can be have sick habits. They can be people that we despise, but they are also citizens, and I think they have and should maintain rights as citizens. And I think they should be compensated when government has done them a great disservice. I know of one fellow that was turned down on the purchase of a home simply because he found out that the home was not 2,000 foot away from a daycare center. The home had just had been cut in price, but this gentleman couldn't take advantage of that because he was under this 2,000 foot rule. What kind of costs should we assess government when they make that kind of a goof? Well, there's been a number of bills before the state legislature, and one of those bills looks to be a helpful bill, and this is House File 2181. It means we've got at least 2,000 bills before our General Assembly. Only a tiny portion of those ever get out of subcommittee and onto the floor of their chamber, and then cross the rotunda to the other chamber, get taken out of subcommittee in the other chamber onto the floor and voted, and then hiked off to the governor's office for signature. Only a tiny proportion of that. But here's a law that I think that should be seriously considered. In fact, I think that should be expanded. And I'll tell you a little bit about it. It's an act relating to a violation of child custody and visitation orders. We are experiencing a multitude of problems in this area of child visitation, where an angry parent says, no, you're not going to see the kids because I didn't get my way, or you didn't turn in your child support, or you didn't do this, or you didn't do that. You're not going to see the kids. And I think there ought to be a contempt of court charges filed in those kinds of cases. But this one speaks to an even tougher case, and this is where a spouse has concealed or hidden the children or absconded with the children. And so House File 2181 is one that you might like to promote with your state legislator and with others who influence those things. Upon the filing of a complaint of a missing person who is a child who is the subject of the alleged criminal activity described in sections 1 and 2 of the law enforcement agency having jurisdiction, shall comply with all federal and state requirements relating to missing persons reports. In other words, if the ex has waltzed off to Alaska with your children, you can report them as missing, and all of a sudden that triggers all kinds of activity on the part of law enforcement involving children, including provisions of Chapter 694 relating to emancipated minors. Upon the filing of such a complaint, the law enforcement agency shall notify the appropriate county attorney to obtain a warrant for the arrest of the alleged perpetrator of that criminal activity. I think it should be broadened out to include any time that children are withheld for really goofy reasons from the other spouse when the other spouse has an appropriate access to those children. I think that should be counted as a criminal act. Also, I think that anyone who aids and abets in that, for instance, daycare workers, school personnel, and others who are told by DHS to, to kick father out of the school, or they have all kinds of ways of making it difficult for the non-custodial parent to get access. So I think someone should widen this bill to include those kinds of things. First of all, to include more than just missing people, children, because I think that if you go to your spouse's house and the children are not available for visitation as they ought to be, it does make a difference whether they're missing or whether they're just being withheld by the other spouse. I think the other spouse should have some accountability in this struggle. The kids didn't ask for a divorce, and the kids have rights to have maximum interaction with their natural parents. And a parent who interferes with that, I think, should be taken to task. The name of the individual, the state representative from Woodbury County, is Whited, W-H-I-T-E-A-D. It's not Whitehead, it's Whited, W-H-I-T-E-A-D. And I must compliment that state representative who has stepped forward to introduce House File 2181. Well, there are a number of other bills that when I read you this one is House File 368, and it may not cover quite as many people as that one I just read about the custody issue. This one, House File 368, was introduced in the first half of this biennium. So it's a slightly older bill in terms of its placement in the, as far as introduction of bills. But this one basically makes it difficult for, or it actually erases exemptions that people have, religious exemptions, when they want to get shaken free of inoculations and other medical patterns. Now, what they've done here, too, is not only do they erase the exemption, but then they can actually grab your children if you don't obey what health authorities want for your children. So they come by and do this every once in a while, try to weasel their way into this business of inoculations and try to remove any opportunity for parents to have a say as to how their child shall be cared for. The explanation of the bill says this bill relates to public safety provisions involving the health of children. Code number 256B.8 relates to the exceptions and special provisions involving the requirements for school districts to provide special education to children is amended by striking an exception. The stricken language states that the special education code shall not be construed to require a person who is a member of a well-organized church or religious denomination or whose religious convictions in accordance with these tenets or principles of the church or denomination are opposed to medical or surgical treatment for disease to take or follow a course of physical therapy or submit a medical treatment. What they're doing is they're saying, children generally, before they can enter school, have to be inoculated. Well, there are religious exemptions that are provided in the law as it stands right now, and an outfit called Child Care Incorporated decided they shouldn't be there. So they simply go to they simply go to the legislature and say, let's remove those exemptions that we don't like. Let's don't let Dad and Mom have any kind of a say as to how children are going to be cared for.
And they said a well-recognized church. What is that?
They have their definitions for that too. You might want to speak up. That mic isn't quite as.
Okay.
It doesn't have a switch on it, but.
Okay. Yeah, I just said that the well-recognized.
Right.
Court's playing games with that wording right there.
Last time I showed you how you could contact certain individuals in the state legislature by simply putting a period between their first name and their last name, and then attaching at legis.state.iowa, that's ia.us, and that's works with any of the state legislators. Jody Tymason is a representative from Madison County, and so you just put jody.tymason at legis.state.ia and ask that she help defeat this medical exemption law, the law that would take out of the hands of parents the whole idea of caring for their children, having a responsibility for caring for their children. Well, here's some telephone numbers that you may be interested in contacting. You might be interested in talking to Don or John regarding issues of the Department of Human Services. We'll see you next week. Thank you for tuning in.